ask the question, that is to express an opinion about what he's about to see on the video. That's coming. So with the court's permission, I'm going to make an anticipatory argument. My argument, Your Honor, is that based on what we've heard, that he should not be permitted to render any opinion about what he sees or what he thinks he sees on any of these videos or still photographs. Your Honor, let's start with his qualifications and training. Mr. Aspinwall is a salesman for Glock. In fact, he's been a salesman for Glock for less than 2 years. He works out of his house. He's not a design engineer. He's not a technical engineer. He's not involved in manufacturing guns. And Your Honor, what they're seeking to do, I submit, is to qualify Mr. Aspinwall as an expert in weapons identification. He is not such an expert. And indeed, Your Honor, in an email, in a report, which is a report from Trooper Bates, Mr. Aspinwall told Trooper Bates on the report on February 13th, 2014, Mr. Aspinwall told Trooper Bates that he is by no means an expert in weapons identification. According to Trooper Bates, those were Mr. Aspinwall's words, that he is by no means an expert in weapons identification. So, Your Honor, he essentially concedes that he's not what they are trying to use him as in this courtroom. Alternatively, Your Honor, I suppose, if they're not presenting him as an expert in weapons identification, they are presenting him as an expert in identifying what he sees on a photograph. And Your Honor, there is no such recognized field of expertise. He has no particular, they haven't established any foundation, he has some kind of superhuman eyesight, that he has any special qualifications or credentials to identify what he sees on a photograph. He's never, and Your Honor, there's no evidence to this point, and I don't think there's going to be any, that he's ever testified as an expert in such an imaginary field. So to the extent that he has any expertise at all, Your Honor, if they want to use him to testify to his opinion about what he sees on a photograph, that is beyond his area of expertise, if he has one. And under cases like Commonwealth versus Franzipane, 433 Mass, 527, 527 and 533, 2001, a recent Mass Appeals Court case, which summarizes the cases, Guinan, G-U-I-N-A-N, 86 Mass App Court, 445 at 450 to 453, a 2014 case. Your Honor, it's an abuse of discretion. It will be an abuse of discretion to permit someone to essentially testify or to offer a so-called expert opinion beyond his established area of expertise. Your Honor, the only alternative to rubric is that this is lay opinion evidence. And Your Honor, if it's lay opinion evidence, it's clearly improper. Number one, the video and the photographs, they speak for themselves. And by his testifying as a layperson as to what he believes he sees on those videos, he's essentially usurping the jury's function. And going back to cases like Iannello, he can't usurp the jury's function. It's for the jury to decide, not for the witness to decide. Moreover, Your Honor, would
you agree that if the court disallowed lay opinion, that the court then should reconsider its ruling allowing the exemplar in only as a chalk, since the jury obviously will not have had the chance to study it, have it in front of them, examine it, and with the film? Would you agree that should the court agree or not allow the opinion, that the corollary to that would be the exemplar should come in as a full exhibit?
Absolutely not, Your Honor, because for the reasons that I unsuccessfully argued to the court last week, I don't believe that this particular, there's no evidence that this particular model of weapon was used in this particular shooting, Your Honor. I mean, this essentially is putting something in front of the jury. It's a show-up for the jury and say, here, jury, here's a gun. You look at this gun, and you figure out, and we want you to compare this gun to the video.
He hasn't said, has he, that it's only this particular model Glock that has those unique characteristics?
He hasn't said that,
Right.
Your Honor.
So to the extent
But that's
this
the
is
model.
representative of Glocks, Glock 45s, why wouldn't it be appropriate for the jury to actually have that?
Well, respectfully, Your Honor, because I think the jury would have to have, in order for that to be what we're doing here, the jury would have to have access to, and I'll give it to them if the court will allow me to do it, an array of black polymer semi-automatic handguns made by different manufacturers, Glock and other manufacturers, and the jury, then we can have a fair identification procedure, as opposed to, here's the one gun we want you to look at and use as a source of comparison, which is incredibly and unfairly suggestive. So absolutely not, Your Honor. I don't think the choice is he should be allowed to give his opinion, or else we just let the jury have the single gun. I don't think either of those options comport with fairness, comport with Mr. Hernandez's constitutional rights to a fair trial based on evidence. And, Your Honor, as lay opinion, I mean, it's like Commonwealth versus Austin, 421 Mass. 357, 365, 366. There, Your Honor, a police officer, the SJC said it was improper for the police officer to testify that the person on the surveillance photograph was the defendant. And the SJC said that basically the jurors are capable of viewing the videotape, and they can make up their own minds about what they see on the videotape. A lay witness can't do that. Going back to the 19th century, Your Honor, one of the two fundamental prerequisites of lay opinion evidence, going back to a case called Commonwealth v. Sturdivant, 117 Mass. I think it's at 122 at 137, 1875. Quote, the subject matter to which the testimony relates cannot be reproduced or described to the jury precisely as it appeared to the witness at the time. So if you have a witness who saw a car, the speeding car, obviously the witness was there, the jury wasn't there, so their lay opinion testimony can be allowed. Here, the jury is in the same position as this lay witness to look at that video and look at those photographs, and they can figure out what they think is depicted in there. They don't need some layperson to give his opinion, and indeed, it's improper. And finally, Your Honor, based on the discovery I've received, apparently his opinion is going to be that it, quote, appears to be a Glock. And unless he's changed his opinion since the material I've got in discovery. If that's his opinion, Your Honor, aside from all its other infirmities, that is far too vague, far too indefinite. It essentially invites the jury to speculate, and it's not an appropriate opinion, either a lay opinion or an expert opinion, and I submit the court should not allow it.
Thank you.
Of course, Your Honor, not only does he have considerable experience in the area of firearms, and I don't think that that's really arguable given that he's an instructor and teaches people how to operate them. He's been with Glock now for 2 years, and his job is to do exactly what he just described to the jurors, right? Demonstrate them and be expert in them. He has identified uniqueness, not just sort of this is how a gun works, uniqueness in its relationship to Glock. And all of that was previously disclosed, as well as in his opinion, just as he's now described, the uniqueness of the backstrap and the tang and how it meets the upper receiver or the slide of the firearm. And that's what he has previously said. That's been provided. My memory is we actually had a discussion about this very issue some time ago. And That's what he is going to describe. The photos themselves, Your Honor, the still photos that are taken from the video, and the video shows the uniqueness. He is particularly qualified. We have this issue arise in certain circumstances in the court, particularly in dealing with identification of goods for the purposes of determining whether they are counterfeit, right? It happens all the time. We have the manufacturer's representative come in and testify, this is how we identify our goods, which is exactly what he is going to do. It is not unusual testimony.
Very briefly, Your Honor, I've had no objection to anything he's testified to. I have no problem. He can testify till the cows come home about how unique the guns he sells happen to be. That's different from giving an opinion about what he sees in a photograph.
That's exactly the opinion that I've just identified in relationship to other types of goods, and that's what he's doing. He's identifying his own goods.
Thank you. Do you have a copy of the 86 Mass App Court one?
So which one, Your Honor? The Guinian case?
Yes, I haven't been able to pull it up on the computer quickly.
I'm not sure. I may have it, Your Honor. I don't have it with me, Your Honor. Sorry.
And how do you...
I can print one. We can print one during the recess.
Okay, why don't we do that, and then I'll
Yes, Your Honor.
I'll read that before I roll. Thank you. Take a 15-minute recess.
All rise.
The court overrules the objection. I find that this witness has sufficient education, training, experience, and background, specifically in Glocks and the uniqueness of Glocks, to be able to indicate a juror conclusion between a Glock and what he sees on the video. Could I see a picture of the copy of the photograph as well?
There are a number of them, Your Honor.
Could I just see those?
Sure. I have additional ones, but I think that...
I believe his education, training, experience, and familiarity with Glocks is far greater than the jury will have, and that the jury, and that he is in a better position to make that comparison. I also note that even lay opinion testimony is allowed in cases subsequent to Austin, where the picture is not crystal clear, is not so unmistakably clear that the witness is no better suited than the jury to make the identification. Cases such as Commonwealth versus Pleas, this witness is far better suited than the jury to make that comparison. After looking at these photos, there was some reference to if the court would allow the defendant to produce other firearms. There's been absolutely no preclusion of the defendant. If the defendant has other black .45s that the defendant wishes to put in evidence through this witness or elsewhere, or another witness, and if the defendant wishes to put in 5, 6, 7, 8, however many other kinds of .45s, there's certainly been no ruling that it can't, and if at that time, and if the defendant wanted them marked as not only exhibits for identification, but to go into the jury, the court certainly has not ruled that if the defendant wishes all of the firearms, including this one, to go into the jury, that the court would not allow that. There may be absolutely no opposition from the Commonwealth to turning this exhibit for identification into an exhibit along with other black .45 firearms. That's really the defendant's choice. But to the extent you'd indicated, to the extent there was anything that suggested either the court had ruled the defendant couldn't do that, or any anticipation that that might not be allowed, that has certainly not been precluded if the defense decides that that is something that the defense wishes to do. We can bring the jury back.